Oh, dear. Monday the 11th of March, 10:56 a.m. Haven't done a video journal for a while. So, god damn, I have a mess. Oh, skin is just awful in parts. Oh, I should probably start again, but anyway. God was slow. Matthew isn't here. Pelican book. So Ivor Jennings, The Queen's Government, a full and authoritative account of the machinery of British democracy, the monarchy, Parliament, the cabinet, and the political and legal systems behind them, which I've read all of with fair attention, except for cabinet government, which is pretty fucking boring and not really relevant. It's quite... it's something I can skip. Don't have to go and read it, really. It might be useful to skim through it. Anyway, Chapter 8, The Queen's Justice, Law and Opinion. So we'll try reading 4 pages. We'll see how long it takes. It's good practice. One of the peculiarities of English history is that through the courts, though the courts became subject to the authority of Parliament, they retained a great prestige. Parliament and the courts, and Parliament is in a capital P, the statute law and the common law have, so to speak, been in alliance between equals, in spite of the fact that Parliament could override the courts and the statute law supersede the common law. The high prestige of the judges is peculiar to countries which follow the English tradition. The explanation is, no doubt, that both Parliament and the courts took their authority from the king, capital K, and then formed an alliance against the king. The word, quote, court, has gradually acquired a specialist meaning, a meeting in which the Queen's, capital Q, justices administer law in the Queen's name. There are, however, relics of a wider meaning, as when debutantes are, quote, presented at court, or an ambassador is accredited to, quote, the Court of St. James, court in a capital C. The king held court when he appeared in public, discussed matters with his courtiers, heard petitions, and issued orders on them, decided disputes between persons subject to his jurisdiction, received ambassadors from foreign sovereigns, so other nobles, royals, rulers, received homage, this is printed 56 or something, and this guy was educated, born 1903, educated Bristol Grammar, St. Catherine's, Cambridge, honorary fellow, Court of the Bar in 1923, King's Council 1949, Vice Chancellor, University of Ceylon 1942 to 55, now Master of Trinity Hall, Cambridge, 56, I think this book, found it. It's quite old and ragged. What's my place? Received homage from those who had succeeded as his tenants-in-chief, knighted the sons of great lords, and so on. These functions were gradually differentiated. Some functions are exercised by the High Court of Parliament, High Court capitals, some by Her Majesty's Courts of Justice, all in capitals, and some by the Queen herself when she holds a court. The High Court of Parliament became the greatest of the courts. The Queen's orders in Parliament. Fucking door. Considered asking if I could repair it for them. I don't know. Keep slamming. Became the greatest of the courts. The Queen's orders in Parliament, called Acts of Parliaments, are binding upon Her Majesty's judges and will be enforced by them in her courts of justice. In medieval England, though, Acts of Parliament were few. The law of England was developed not in Parliament, but in the King's other courts, the courts of justice. So by a function, almost by in a market, I don't know, because people would have the option to settle out of court. In history especially, I suppose you would have, the phrasing is taking justice into their own hands, literally, which would have been pretty cool sometimes, like hanging horse thieves. If you found someone had been a bad husband, or even a bad wife, but probably more commonly a bad husband, you'd publicly humiliate them, or beat them, or just ostracise them. The supremacy which the king's courts obtained over the other feudal courts and over the local courts of Anglo-Saxon England created a single coherent system of law, the common law of England, whereas other countries had a mass of local customs which had eventually to be superseded by a code of laws. England had a single system applied by the king's courts in the king's name. This common law obtained high authority because it emanated from the king or was applied to his justices in his name. It contained two principles to which politicians could appeal against the king himself. Two characteristics of the English revolutions are remarkable. English revolutions in capital, as they were officially recognised events, I suppose that means. One is the extent to which constitutional battles were fought in the courts, in leading cases which still find an honourable place in our books. The other is the way in which lawyer politicians dominated the debates in Parliament and quoted precedents at enormous length. I think precedents are bullshit, kind of. I mean, they're a demonstration of where something has been or not been in the past, but it's not something to base something on. It's not a full argument. I don't know. I'm not a fucking legal scholar, but precedents and law, I don't know. The lead was given by Coke, capital C, after his dismissal from the office of Chief Justice, capitals, for he believed that liberty was to be secured by following the principles derived from the precedents to be found in the learning of the common law, which he, quote, shovelled up in vast disorderly heaps. He had with him another great lawyer, John Selden, who almost equally learned in the, quote, black letter law books. The lawyers were less prominent after the Restoration and at the Revolution of 1688, for the period of domination by the great landowners was beginning. The attempts made to, quote, legitimate the accession of William and Mary were, however, I suppose it's Mary of Scots. Is that 17? I don't know my monarchs. I'm actually uneducated. Were, however, a remarkable tribute to the power of the common law. The emphasis of this common law of the Constitution was placed not on theoretical principles of political obligation, but on practical principles of legal administration, so it had to actually work, to function. Because people actually needed disputes resolved. Or, what is the proper term? Needed damages redressed, or whatever. The conflict between prerogative and Parliament, both in capitals, was in large measure a conflict over prerogative courts, the right of taxation, the suspension of and dispensing from the laws, arbitrary arrest, trial by jury, habeas corpus, which I don't actually know what that means, which I should know. It's probably an important concept. Though the courts could be overruled by Parliament, they could not be overruled outside Parliament. It was their duty to see that the law was observed, even against the King, capital K's, officers. So, fairly universal. And actually this was carried to its consistent end with Charles I having his divine right to rule challenged, and, the Civil War. And yeah, they cut off his head. That's a whole other thing. A public opinion developed after the Restoration, capital R, and the subjects debated in the Commons were also debated in the coffee houses. This public opinion was concerned not so much with constitutional rights as with constitutional wrongs and constitutional remedies. The common law was concerned with the protection of liberties by granting constitutional remedies, and the function of Parliament, capital P, was not to destroy the common law, but to fulfill it by removing, for instance, qualifications and restrictions on the writ of habeas corpus. This remarkable alliance between Parliament, capital P, and the law courts, statute law, and common law, political opinion, and popular opinion continued in the 18th century. John Wilkes, actually, wasn't it John Wilkes Booth, or someone who killed Lincoln? Different guy. Became a natural hero not because he was cast in a heroic mould, but because two legal questions were fought over him. whether a Secretary of State, in capitals, could issue a, quote, general warrant for the arrest of the seizure of the papers of a person unnamed, and whether the House of Commons, capitals, could by a resolution disqualify a person from election to the House, capital H. These problems were thought worthy of the attention of the greatest statesman of the age, William Pitt, Earl of Chatham. What is more, the American Revolution, capitals, was fought over legal issues, whether the Parliament of Great Britain, capital, could tax the capital A American colonies without their consent. Something about tea, I think that was, as well. Or having their guns confiscated, or attempted to be confiscated. And basically they couldn't, I think it was the Atlantic was too far to traverse, you couldn't actually effectively communicate. So the only real solution, the only way they could practically function was as a fairly independent colony. The time delay, couldn't work, really. But anyway. Here not only William Pitt, but also the greatest publicist of the period, Edmund Burke, thought it necessary to collect the precedents and discuss legal issues as part of the wider issues of personal and political liberty. The French Revolution, in capitals, caused reaction in a Britain which was rapidly becoming industrialized, with a Z. Should be an S there. It's bad spelling. The landowning class feared the ideas of liberty and equality which were spreading among the rapidly growing urban working class and the hardly less dangerous, in an economic sense, industrial middle class. The flag of liberty secured an unlikely standard-bearer in Charles James Fox. He, it is true, knew little of the law and perhaps cared less, but necessarily the Foxite Whigs, capitalized, emphasized the ancient liberties which were believed to have been secured by the Revolution of 1688. Fox's name was attached to the Libel Act of 1792, which reverted to the old rule exhibited in the italics case of the 7 bishops, but denied by Lord Mansfield as Chief Justice, that in a case of seditious libel the jury was to bring in a verdict of guilty or not guilty, and not merely to decide whether there was proof of publication. This act, capitalized, enabled juries to adopt what seemed to them to be a common-sense view of sedition instead of the legalistic and oppressive view which the judges would probably have adopted, notwithstanding the enactment of oppressive legislation in the notorious, quote, 6 Acts of 1816, the reluctance of juries to convict persons who seemed to them merely to have expressed opinions not favoured by the unrepresentative governments, capital G, re-established the freedom and tolerance which had been characteristic of Britain during most of the 18th century. That's quite a long sentence. This history shows how deeply the principles of constitutional law had bitten into public opinion, which broadened as larger sections of the people became wealthy and literate in the development of the Industrial Revolution, capital I, capital R. Even the necessary reform of the police, which Peel, capital P, introduced in 1829, reform of the police. I think that shifted from the old model of magistrates and county sheriffs, or whatever the fuck. I think even way back, knights used to be legal actors, sort of. They'd resolve disputes, perhaps. Squires, that was the other one. Squires would enforce things, I think. Chase down criminals. I don't really know. Was resisted as an attack on liberty, with the consequence that the policeman became not an instrument of a despotic government, but the, quote, capital B, Bobby, standing at the street corner, anxious to help anybody in trouble. Then you had those police boxes with, what are they, blue? Yeah, like, I don't want to mention Doctor Who, it's gay shit at this point. The popular prejudices exhibited not only in the leading articles and the debates in Parliament, but also in the saloon bar and the tap room, are founded upon a long tradition of opposition to interference with individual liberty. Quote, it ain't right, and, quote, they didn't ought to do it. I should that should be in a rougher accent, are relics of the ancient constitutional conflicts. Coke and Selden, Pym and Hampden, Pitt and Burke, Fox and the defendants, I don't know any of these guys, really. Fox and the defendants of oppressive litigation have written their opinions into popular ideas. This is important in two respects. First, it makes Parliament a rapid and efficient instrument for protection against interference with individual liberty. The House of Commons is at its best when individual grievances of some constitutional importance are raised, even by persons of as little merit as John Wilkes. Secondly, the courts enjoy public esteem in the protection of liberty. It protects them against political interference and enables them to exercise their functions, quote, freely and fairly, without favour and without fear. And I suppose I'll have to include just take a second here, summary in text of the case of John Wilkes. Fuck. I'll have to find something of that somewhere and include it. Alright. I hope that was as interesting to you as it was to me. It's very dry old legal history. But it's fairly well written. He's a thorough author, so yeah. I'll leave that there.